Hello aspirants, welcome to Excellence IAS Academy. Recently, Chief Justice of India, Sanjeev Khanna, has recused himself from hearing particular case. In this context, we will discuss about recusal for your UPSC examination, especially for your GS2 paper, Indian Polity and Governance. Let's begin. Recusal. What is a recusal? Recusal is a legal process. It's a legal process in which a judge steps aside from hearing particular case. It is based on the principle of natural justice. Principle of natural justice. Especially the saying principles of natural justice, especially one should not be a judge in his own case. One should not be a judge in his own case. This, based on principle, the recusal came into picture in judicial system. And also based on the other principle is that justice must not only be done, but must also seem to be done. Based on this principle also, recusal came into picture in judicial system while delivering justice to the people. And how judge recuse himself from particular case? How judge recuse from particular case? One instance is that automatic recusal. Judge recuses himself from particular case without any external appeal or external pressure. He himself cites that there is a potential for conflict of interest or biasness. So in this case, he automatically recuses himself from particular case. For example, EU Lalit in 2019 Ayodhya dispute case, Ayodhya land dispute case, EU Lalit recused himself from hearing that particular case. And also in Geeta Gopi of Gujarat High Court recused herself from hearing Rahul Gandhi case. So these are the instances of where automatic recusals happened. And secondly, appeal. When a party is involved in particular case, appeal to the bench saying that this particular judge should be recused from this particular case. So in that instance, it is judge who decides whether he should be recused from himself or not. Because this recusal is not mentioned in any statute. There is no codified laws for the recusal in the country. Hence, it is a matter of discretion for a judge to while considering a recusal from himself from particular case. So in this case, for example, when we can take about the example of former Chief Justice of India, Chandrachud. He, even though appeal made for his recusal, he refused from, say, the case of same-sex marriages. And also, the former Chief Justice of India, Rangan Gogoi, he also refused to recuse from the NRC case because there was appeal for his recusal from NRC case because he hails from Assam. Appellants has cited that there may be a conflict of interest or biasness towards some particular parties. So even reasons for recusal, Ranjan Gogoi refused to be recusal. And well, when recusing, a judge should be given reasons. It is mandatory. There are many reasons, but why the judge recused, and he should be given reasons while recusing. We'll look into that. Firstly, as there is no codified law for recusal, judge, it is mandatory. It is not mandatory for a judge to give reasons, because, for example, you can take about Bhima Koregaon case. In that case, 5 judges of the Bombay High Court recused themselves from this particular case without any reasons. And also in Balkis Bano case, in this case, Justice Trivedi recused himself without giving any reasons. and it is not mandatory to give reasons. It is a discretionary. Again, it is a discretionary of a judge to give reasons while recusing. And what are the reasons to recuse? There are many reasons. What are the reasons for recusals? One, potential of conflict of interest. When judge feels that there is conflict of interest because he already have some opinions about particular issue or particular judgment or particular thing. So in that case, there might be a biasness or maybe not being fair in giving judgments. So in that case, judges recuses himself. For example, A.K. Sikri, he recused himself because he cited that there might be a conflict of interest if he is part of the bench. And relationship between the parties and judge. If there is any relationship between the parties involved in that case and also the judge, in that case also judges recuses themselves from the particular case. And thirdly, prior involvement of the particular case. For example, prior involvement. When judge was High Court judge, he elevated to the Supreme Court judge. But while he was in High Court, he already had a involvement in that particular judgment. So after he became the Supreme Court judge, the case appears to in Supreme Court. In that case also, judges recuses from themselves from hearing case. And also, you know the oath, right? Supreme Court judges take oath by stating that they will discharge their duties without any fear or favor, and also any affection, favor or any affection. So because of this oath, they have to maintain some impartiality, accountability or transparency. Because of these reason also, judges recuses from themselves. This is the main idea with respect to recusal. There are many Supreme Court judgments with respect to this particular recusal, and we will come up with a particular video about in future days. Thanks for watching the video. Stay tuned.